Welcome to Discover a New Future, a show geared at empowering women to be the best versions of themselves. I'm your host, Faith Saunders. Well, I am so happy to have my guest here today. She's going to help us to sort out a lot of words that we hear, but sometimes we're not really clear what this is all about, right? So I want to welcome Elizabeth Candido Petite. Did get it? Who's an attorney at Lindabury, McCormick, Estabrook, and Cooper. Yes. And she specializes in the area of estate planning and administration and tax law. And this includes, these are the things that she's going to explain to us, or explain to me, wills, revocable and irrevocable trusts. What are these things? We hear of them, but we don't know what they are. Durable power of attorney and advanced directives for healthcare. I like to hear people's backstory. You could do any law under the sun. Why did you choose? Why did you choose estate law?
So I went to law school right after college with the idea of being a lawyer, but I didn't really know what that meant. And then my first classes in law school were torts, meaning personal injury, and contracts and civil procedure, and I was like, this is so boring, I hate all of this. And I was questioning whether I wanted to even be a lawyer anymore. And then my second year, the first class I took was wills and trusts. And I was like, this is exciting. This really hits home. This is what happens to people. They have to plan for their families. They have to make sure that their property and their estates are taken care of, and there's a big emotional part of this because everyone's concerned about making sure their families are provided for, and I just thought it was fascinating. So I followed that path, and then I ended up getting my tax LLM, which is a master's in law degree for specializing in tax law because it's so complicated.
That would in itself is like, oh gosh.
And a lot of estate planning deals with trying to reduce or minimize or eliminate entirely any taxes that you pay at your death. Probably if you ask 9 out of 10 people, they'd say, I don't want the government to get any of my money when I die. So, and that's true.
I think I said that too.
That's true whether you have $10 or $10 million. So everyone's in the same boat there. So a lot of the more sophisticated planning that I do is really focused on how to legally avoid paying taxes.
So that's very interesting. I like to hear backstories, you know, because you can't put a person, you know, like human. So yes, as I mentioned, you know, all these terms, we hear them so often, but we have no clue what they mean. How they're applicable to us and how we can actually utilize this in our lives. So let's talk about will, right? So let's first take that one is the most familiar to many of us. So what is a will?
So a will is a document that everyone should have that states what you want to happen when you pass away. It can do a couple of really important things. For example, the first thing that it always does is say who gets your property. Is it going to be your spouse or your children or friends or parents or, you know, depending on who and in what proportions. And if you have young kids or maybe someone with special needs that can't manage property on their own, you're probably going to put it into a trust so someone else can help them manage it for them to protect it from them. So that's the first important thing. It controls what happens to your property. The second important thing is that it appoints the people who will take care of your property, and that's called an executor. That's the person that manages your estate. And also, if you have children, you're going to want to appoint a guardian. And if you and your spouse, or if you don't have a spouse, just you, if you pass away and you have minor children, that's going to be the person who sort of steps into the parental role legally to make sure your child is properly raised. And then the last, probably most important thing that the will does is that it authorizes those people that you appoint to serve without bond. Otherwise,
what does that mean?
So bond is it's almost like an insurance. So if it's to protect your property basically from the executor or the guardian stealing it or mismanaging it. And the bond is an annual fee that has to get paid out of your money. So presumably you're appointing people that you trust and you know are not going to mismanage your property. So you don't want to be spending a couple $100s a year on bond.
Wow. I didn't know that about the bond portion of it. Oh, wow. So, so this is after I passed, that's when you start paying the, sorry, I don't want to go any soon, but when a person passes, that's when the bond comes into effect?
Right. Everything in the will only comes into effect when you die.
Right.
So if you were really meticulous, you could write a new will every single day for the rest of your life.
I don't think so.
And only the one that was the last one that you wrote would be the most effective one, which is why it's sometimes known as a last will and testament.
Okay, I see. So people go to an attorney to write a will? Is that the whole process that you have to go to an attorney?
It's not required. Anyone could write a will. You could write it by hand even and just sign your name on it. But when you go to an attorney, then there's a more of a presumption that it's been done properly that's on the one hand. And the second hand is that the attorney will really sit you down and talk you through all of these different aspects to make sure that everything's covered. So, for example, I met with a client or a prospective client just a few days ago, and their dad passed away, and they had a will that the father had written out by hand. That's called a holographic will. And it said who was going to get the property, and he signed it, but it didn't appoint an executor. So then the question is, who's going to serve as executor? And the law does address these situations if you don't have a will or if you don't name an executor. But if you're going through the exercise of planning for your property, you might as well just do it thoroughly.
That's a good point. That's a good point. So, so if I don't have a will, what happens?
Well, some people think that the state gets everything, and that's most likely never going to happen. Because if you die without a will, there's what's known as the intestacy statute, and that directs who's going to get your property. And it's based on what I'd say 90% of people would do anyway. If you're married, you give it to your spouse. If you don't have a spouse but you have kids, it goes to the kids. If you don't have a spouse or a kid, it goes to your parents. Or if they're not around, it goes to your siblings or their kids. Or
So it goes down.
Right. It's kind of like take a look at your family tree and who's the closest relative to you, and it goes to those people. So it doesn't just disappear. It will go to someone, and those same people that I just listed are the people that could serve as executor, or technically when you don't have a will, that position is known as the administrator of your estate, but the functions are basically the same.
So, all right, the person has a will, but so often you hear the person, this is their last will and testament that A, B, and C should happen, but people contest the will. What's that about?
So you can't disinherit your spouse. If you name other people besides your spouse is going to file for what's called the elective share, and that's typically 1/3 of your assets. Although the computation can get very complicated because it also depends on what they have and what you own together and a whole other host of factors, but essentially 1/3. So that's one type of will contest, so to speak. You can disinherit your children, or you can say, I want my son to have 80% and my daughter to have 20%. Well, your daughter might not be happy about that.
Right.
So that's when will contests would arise. Your daughter would probably then file a will contest saying, I should have gotten more than what I'm getting in the will. Maybe the brother had been living with the mom and he had unduly influenced her to give him more than sister. So that's when people's true colors, I guess, really come out. Unfortunately, sometimes it just tears the family apart. I mean, sometimes it's a legitimate reason. You know, sometimes it's not family members fighting against each other. It's a caretaker who maybe had worked with mom for several years and, you know, really nudged her way in there and had mom write her in the will, and the children don't like that.
Wow. How based on your experience, how often does these contested wills, you know, goes in the favor of the person who is contesting?
Pretty rarely, to be honest. If it's proven that the will was executed properly and that there's no sign of undue influence or fraud in the making of the will, then this is the person's wishes, and even if you don't like it,
That's what it is. That's what it is.
Right.
It's what it is.
Right.
Wow.
Now, a lot of times these don't get played out to the end in court because the families or the parties will take a look at this, and litigation's expensive and it's a long emotional process. So a lot of times it gets settled and everyone gets something.
That's interesting. So I think you just said, and correct me if I'm wrong earlier, that you can't disinherit your spouse.
Correct.
But you can disinherit your kids.
Yes.
Oh, okay. So the law is saying, even I didn't like this man, but I don't want him to get what I have. The law says legally he cannot be this. That's what you're saying.
Right.
Oh, wow.
Right. He's not, your spouse can't necessarily get all of your property. That's part of the complicated calculation, but they are entitled to a portion of it.
Wow, wow. And this is if you're married. If you're divorced, it's just nothing.
Right, of course.
Nothing.
Yeah. Or if you've never been married, then there is no spouse.
Right. So let's talk a little bit more about the executor.
Okay.
Yeah. Who can be an executor? Anybody that's person identified?
Anyone that's an adult. You wouldn't want to name a minor child. Ideally, it's going to be someone that you inherently trust. Most people would name their spouse or maybe a parent if the parent is able to do it, if it's not too old, a sibling, a child if you have an adult child, or a close friend. It's someone that you trust, that you know is going to honor your wishes and make sure that all of your property is distributed in accordance with your will. So that's probably the most important role that the executor has, but they also have to make sure that if you had any debts, if those are paid, like the funeral bill, if you were sick and you had medical bills, those might come in after your death and those have to get paid. Maybe you have a credit card bill outstanding. Maybe you owned a house that no one in the family wants, so it's the executor's job to then sell that house. And so collect all the proceeds, go to whatever banks you have accounts at, and usually they consolidate all the money into one fund, pay all the expenses. If there are taxes due, they'll pay those. And then at the end of the day, they distribute it in accordance with the terms of the will.
Okay. So the executor, although they may not be the cosign on the person's bank account, having that document saying this person is the executor gives them that power.
Exactly, yes. After you die, you do what's known as probating the will, which means you go to court with the will, and then the executor swears an oath that they will administer the estate properly. And they're not under court supervision because they can go out and do it on their own, but it's a position of trust. So if it turns out that they are doing it improperly, the beneficiaries can utilize the court system to make sure that those whatever wrongs are righted.
Wow, I'm learning so many things. So what if somebody has like a disabled child, a child who has a disability, and they want to make plans for that child?
So this is probably becoming a lot more prevalent these days because more and more kids are having disabilities. The biggest thing is that you never want to give anyone money outright. It needs to be in a trust. And the reason for that is that if they are already on government benefits like SSI or Medicaid, or if they can become eligible for those in the future, then the government would look at this money and say, this money is available for you. Why are we going to spend our government money if you have this money? Right. So the best thing is and that's not to say that you want to hide your money from the government, but there are a lot of really good programs that the government runs that sometimes you're only eligible for if you're on Medicaid or SSI. So you would want to create what's known as either a special needs trust or a supplemental needs trust. It's essentially the same thing, but two names for it. So the money in that trust can be used for whatever the government is not providing. So that's the supplement part, supplemental. So for example, if the government is providing housing for the disabled child, then the money in the trust wouldn't be used to pay their rent, but it might be used to buy them some new clothes or take them on a trip with other family members or maybe, go out to a restaurant every week or something with them, those types of expenses.
That's interesting. So the money in the trust is for things that the expenses for this person that is not covered by the government or other entities,
Correct.
right? And that's interesting. So, all right. So I'm getting it now.
So I will say that there are lawyers that do only special needs planning because there are a lot of really complicated rules when you get into the world of Medicaid and SSI. So if you or anyone you know does have a child or maybe a parent or a sibling with special needs, it's especially important to talk to a lawyer to make sure that everything's done properly.
So you talked about a special needs trust. You just talked about that. So what is a revocable, irrevocable trust? Is that something different?
Yes.
Okay.
And those are two different things.
Okay. All right. Alphabet soup.
So you don't even know. So a revocable trust is a trust that's created during your lifetime. It's similar to a will in that you can revoke it or rip it up or amend it or terminate it or make any sorts of changes to that you can think of during your lifetime.
Okay.
Or at least while you're competent. If you become disabled, then you wouldn't have the ability to make changes anymore.
When you say disabled, you mean mentally?
Right.
Okay.
So the terms of the revocable trust generally provide for to use whatever funds are in the trust for your own care, for your spouse's care, if you have kids, as if the money was your own, because you can change it whenever you want. So, like, for example, for tax purposes, you haven't really done anything. The money is still considered yours for tax purposes. And then a lot of times a revocable trust will then include provisions about what happens when you die. So that's how it's like a will, because it has the same sort of, I give 50% to my daughter, 50% to my son, whatever the case may be. It could keep it in trust for their lives or a portion of their lives, maybe until they turn 25. And then the person who handles all of that, instead of being called an executor, is known as the trustee.
So if it's like a will, what distinguishes them from the will?
So any property that you actually put into the trust during your lifetime is what's known as non-probate property, and that doesn't have to you don't have to go to court to get authorization to act on that. So as you said before, the executor has authorization, like a little card, although it's actually a full piece of paper, from the court that allows them to access the decedent's bank accounts and collect all their money. The trustee can do that immediately.
Okay.
So they have the power. So usually a revocable trust, you would name yourself as trustee during your lifetime, and then say upon your death, your spouse becomes trustee. So the only thing that your spouse would need to access all those funds is a death certificate to prove that you are deceased. Right? And because it avoids probate, sometimes that helps if you suspect that there might be a problem between family members. If you don't have family members, sometimes it's better to put it into a trust, because then it's just sort of like one step removed from being contested.
Right.
Although that's not to say that revocable trusts can't have contests. Right. But the other thing is, if you know that you're going to leave your money in trust for your children, maybe for their entire lifetime, the trustee under a revocable trust is not necessarily under the court's control. Whereas if you create a trust in your will, that's called a testamentary trust, then those trustees are under court supervision, or the same way that the executor is. So if in 30 years the trustee passes away or wants to resign or whatever, that would be a court procedure to get the trustee, to get a new trustee put in.
You brought up a good thing that just came to my mind. So, all right, if I'm an executor for someone's will, and God forbid something happens to me, what happens?
I always recommend that you kind of name an order.
Okay.
So you'd say, for example, I appoint my spouse as executor, but if my spouse can't serve or fails to serve or whatever, then I appoint my sister. And if my sister can't do it, then I appoint my other sister or my brother or my daughter. I mean,
so you have a list of
exactly.
people. Oh, okay.
And that's the same for a trustee. And the wills that I draft, I always say that the last serving person can appoint a successor. So you never have a point where there's no one who can serve. The trust will never fail because there's no trustee. If that ever was the case, then the beneficiaries could petition the court to have someone appointed as trustee. But again, delays, costs, you know, part of the reason of doing a trust is to avoid some of that. Right. You had asked about an irrevocable trust as well. So that's a trust that generally can't be changed. And those are usually created for tax purposes. Those are considered gifts for tax purposes, so it removes whatever assets you put into that trust from your estate, which means when you die, if your estate was subject to estate tax, that asset wouldn't be part of it. The caveat is that you don't have control over that asset anymore, depending on the terms of the trust, but generally. So that's more of a sophisticated estate planning technique that clients that have a lot of money.
I was just going to say that.
Yeah, so at the moment, the federal government taxes your estate only if you have more than $11.4 million. People do.
Wow.
But that number has changed a lot over time. As recently as maybe 10 years ago, it was like $3 million.
Wow.
Which is still a lot of money, but not $11 million. And this law changes, actually, it had just gone up from about 5.5 to 11 about a year and a half ago during the Trump tax cuts. That was one of the provisions in there. So it's always changing. There are people in government that want to get rid of the estate tax entirely. There are others that want to tax every penny. So it sometimes depends on which party's in control.
Wow.
Yeah. Actually, New Jersey just recently repealed their estate tax. So at the moment, there's no New Jersey estate tax, which is good news.
It is.
The limit used to be $675,000.
Which is still a lot of money.
Yeah, I mean, but think about it. A lot of people in New Jersey, if you own a house and you have a retirement account and a bank account, you might be there without even realizing it.
Okay. Yeah, because it puts the house, everything adds up. Okay. Wow. So, so do I have to pay taxes after I die? I'm no longer here.
Well, unless you have more than $11 million, there's no federal tax. And there's no New Jersey estate tax. New Jersey does have what's known as the inheritance tax, and that's based on who you give your property to, not the amount that you have. So if you're giving your property to a spouse or a child or a parent or a grandchild, any sort of like lineal descendant, there's no tax. But if you're going to give your property to siblings or nieces and nephews or friends or anyone else that's not related to you, then there is a tax. And that depends on who you're giving it to and the amount that you're giving.
So that will depend on the amount of tax.
Exactly. If you give your property to charity, then that's not taxed. So if you're charitably inclined, that's a way to avoid it.
Way to go.
The other way to avoid the inheritance tax is to make gifts during your lifetime. However, if you make gifts within 3 years of your death, then they might pull those back into your estate. So it's not a surefire way. And also, unless for whatever reason you don't need any money to live on, you probably don't want to give it all away during your life. No one has the magic number as to when your time is up.
Yeah, exactly. So. Wow, this has been very, very helpful. I learned so much.
I'm glad to hear that.
Yeah, I learned a lot. It's like, whoa. So, wow, time goes by when you're having fun. The mental show is almost over. So, in parting, what would you say to young folks? Let's talk about young people. What's your closing word to like a young person?
So, a lot of people think that I'm going to live forever and I never have to deal with this, and that's not true. Everyone's going to die. Hopefully, it's later, but if you care about your family, especially if you have young children, then I really highly recommend meeting with an attorney, getting a will in place. If it does nothing else than names who's going to be the guardian for your children, then you've accomplished something.
Wow.
Because, you know, the best legacy you can leave your family is making sure that they're taken care of.
Wow. Well said. Well said. Thank you so much, Elizabeth.
You're welcome.
You're
It's a pleasure.
Yes, we learned a lot today. And to my viewers, I hope you learned something today. As Elizabeth mentioned, especially if you have children, young children, this is so important. And hopefully you got some clarification, like I did, regarding these different entities. So we hopefully you got this in some information that was helpful. And Elizabeth, if someone wants to reach out to you, how do they go about doing that?
My law firm has a website, lindabury.com, and through that website you can contact me or any other attorney at the firm. You could also call us. Our number's on the website.
Okay.
And we work with all types of people that need help. So.
And what county? Do you have specific counties, or it doesn't matter?
Well, my office is in Westfield. Sorry, we also have a Red Bank office and a Summit office. So most of our clients come from those areas. But you know, if you want to meet with us, we'll meet with you. There's also great attorneys all over the state, so you know, you're not limited to working with us.
That's great. That's great. Well, thank you everyone for viewing us again, and until next time, think positively.